You know that feeling when you're trying to get your head around something really complex, maybe for work, or maybe just, well, because you're curious?
Yeah, like wading through tons of info and not quite sure what's actually important.
Exactly. And that's really why we're here at the Duck Dive. We try to take those tricky topics and, pull out the key bits, the stuff you really need to grasp.
And today, we're diving into something pretty fascinating, actually. Patent law in India. We're going to unpack a recent, quite significant legal battle at the Delhi High Court.
Right. And this case really shines a light on the rules around changing patent applications after they've been filed.
Mm.
So our mission for this deep dive is to really understand the ins and outs of amending patent claims under Indian law. We're focusing specifically on a case involving the pharma company AbbVie,
Oh, yeah, AbbVie. Big name.
big name, and their attempt to shift their patent claims for an anti-cancer drug conjugate. They started with method of treatment claims and then tried to switch to claiming the product itself.
Quite a change. And to help us navigate this, we've got some pretty good materials, right? Detailed notes on the High Court's judgment.
Yep, the full judgment itself and some important background info to give us the whole picture.
Good stuff.
So get ready, because by the end of this, you should have a really solid understanding of the legal principles, why the court decided what it did, and importantly, why this whole thing matters if you're interested in IP innovation or, how these laws shape new tech.
Definitely. Okay, so where do we start? The core legal bit.
Yeah, let's start there. The heart of this case is Section 59(1) of the Indian Patents Act, 1970. That's the key law saying how and when you can amend patent applications once they're in the system.
That's the one. And in this AbbVie case, the Delhi High Court really relied heavily on an earlier decision from their own court, actually. Nippon, A&L Inc., v. Controller of Patents.
Okay, the Nippon case, what did that establish?
Well, it basically laid out 3 conditions, and this is crucial.
Yeah.
All 3 have to be met for an amendment to be okay. It's not like you can pick and choose.
All or nothing. Got it. And those 3 conditions are?
Okay, first, the amendment has to be by way of disclaimer, correction, or explanation. That's kind of the what type of change part.
Disclaimer, correction, explanation. Okay.
Second, the amendment must be for the purpose of incorporating actual facts. So grounding it in reality, essentially.
Makes sense. And the third, you said this was where AbbVie ran into trouble.
Yeah, this is the big one, especially here.
Yeah.
The amended claims have to fall completely within the scope of the claims you originally filed, along with what you described in the initial patent specification.
Wholly within the original scope.
Exactly. And critically, you can't add new subject matter that wasn't, substantially there from the start.
Okay, that really sets the legal framework.
Yeah.
Now let's look at AbbVie's situation. Their original application, the title was something like anti-cMet antibody-drug conjugates and methods for their use. Sorry.
That's it. So even the title gives you a clue about the initial focus, methods for their use.
Yeah, definitely points towards how.
And if you looked at the actual claims they first filed, they were all about methods of treating certain cancers, specifically cancers with too much pigment protein, like non-small cell lung cancer, NSCLC, with particular protein scores.
So very specific.
Very specific. The claims even mention things like dosing schedules, how to give the drug, how to pick the patients based on those protein levels. You saw phrases like administering to a human subject all over those initial claims.
Okay, so AbbVie was clearly focused on how their anti-cMet ADC was meant to be used in a very specific scenario. But then the controller, the patent office, pushed back.
They did. The controller raised objections based on a couple of sections of the Patents Act. First, Section 3I. They said these method of treatment claims aren't actually considered inventions under Indian law.
Ah, the bit that excludes medical treatments themselves.
Exactly.
Yeah.
And they also argued the claims lacked industrial applicability under Section 2.1. Basically, you can't industrially produce a method of treating someone in the same way you produce a drug.
Right, that tracks. It's not a tangible product you manufacture. So facing those objections, AbbVie thought, okay, let's try something else.
Precisely. They tried a pretty major pivot. Instead of focusing on the method, they tried to amend their claims to cover the product, the anti-cMet ADC itself, and its compositions.
So claiming the actual drug conjugate substance.
Yeah. The idea was the patent would cover the compound itself, no matter which disease it might be used for or how it was administered. They filed a new set of 8 claims reflecting that product focus.
Okay, and here's the crux of it. The court looked at this switch method to product and essentially said, nope, can't do that.
That's exactly what happened. The Delhi High Court found AbbVie's amendments weren't allowed under Section 59.1. They went through the different types of permissible amendments, disclaimer, correction, explanation, and said AbbVie's changes didn't fit any of them.
Okay, let's walk through that. Why wasn't it a disclaimer? Weren't they maybe narrowing it in some way?
Well, the court said the opposite, really. A disclaimer usually reduces the scope, maybe cuts something out to avoid prior art. AbbVie's amendment, by moving from a specific use to the general product, actually widened the scope.
Ah, okay. Broader, not narrower. Got it. What about calling it an explanation, just clarifying the invention?
The court didn't buy that either. They called it a complete transformation. Moving from method claims to product claims wasn't just explaining something better, it was fundamentally changing what was being patented.
A transformation, not an explanation.
Okay.
And correction. Could they argue they just made a mistake drafting the first time?
Again, no. The court viewed corrections as being for, obvious errors, maybe a typo or a clerical mistake. Changing the entire category of your claims from a how to use to a what it is, that's way beyond a simple correction in the eyes of patent law. It's a substantial shift.
So if it wasn't a disclaimer, explanation, or correction, the main problem must have been the scope, that third condition from Section 59.1, staying within the original lines.
Exactly. That was the core of the court's reasoning. They found the amendments resulted in a significant enlargement of the patent claim's scope. Remember, the original claims were tied very tightly to treating specific cMet overexpressing cancers, especially NSCLC, with those defined protein scores.
Right. So originally, the protection was only for using the drug in that specific way for those patients.
Precisely. The protection was limited to the ADC when used for treating NSCLC patients with those IHCH scores following certain regimens. But the amended claims, they tried to cover the ADC product generally, regardless of the disease, regardless of how it's used.
Big difference.
Huge. And the court specifically pointed to the removal of the disease limitation, getting rid of the NSCLC focus as a key reason for finding the scope was broadened. The court said the amended claims would give AbbVie additional protection they simply didn't ask for initially.
That makes it really clear. They were essentially trying to get more coverage than they originally applied for.
Absolutely. And there was another point, too. The court noted AbbVie introduced brand new claims, claims 5 to 8, dealing with pharmaceutical compositions of the ADC. Those types of claims weren't in the original filing at all.
So adding new stuff, too.
Right. And the court even brought up the Supreme Court's view from the famous Novartis case, cautioning against trying to artificially broaden claims just by clever wording, rather than basing them on what was actually invented and disclosed up front.
Okay, now, AbbVie did try to use another case to back themselves up, didn't they? The Allergan case.
They did, yes. They pointed to an earlier Delhi High Court decision, Allergan Inc., Controller of Patents. In that case, a similar kind of amendment method of treatment to product claims was actually allowed. So AbbVie argued, hey, our situation's like Allergan.
But the court in this case, the AbbVie case, saw a difference. How did they distinguish it from Allergan?
Yes, and this is a really important distinction they made. The court looked closely at Allergan and said essentially, not so fast. They pointed out that in Allergan, even when the claims were changed to product claims, those amended claims still related to the same specific disease that was in the original application. The therapeutic focus didn't change.
Ah, okay, so in Allergan, even with the product claim, it was still tied to treating, say, condition X.
Exactly. But in AbbVie's case, the amended claims dropped the disease link entirely. They weren't just trying to protect the ADC for use in those committed cancers. They wanted protection for the compound itself, full stop. That removal of the disease context was the crucial difference. That's why the court said AbbVie's amendment broadened the scope, unlike Allergan.
That's a subtle but critical point.
It really is. And the court also noted that the Allergan judgment hadn't really dug into whether that amendment specifically met the disclaimer, correction, or explanation criteria of Section 59.1.
Interesting. So it's not just if you change claim type, but what else changes, like removing limitations. Okay, what about the other side? What arguments did the patent office, the assistant controller, make against the amendment?
Well, the controller had a few key points. They mentioned Section 138(4), which deals with applications coming into India from the international PCT route. The argument was basically that the Indian application should generally stick close to what was filed internationally.
And AbbVie hadn't included product claims internationally.
Right. They hadn't amended their claims during the PCT phase to add product claims. So the controller argued that trying to add them later in India was, well, problematic.
Keep things consistent, essentially.
Kind of. They also pointed out that even when AbbVie first entered India and made some initial tweaks, the claims were still method of treatment claims. The jump to product claims came later. And of course, their main argument was the one the court agreed with. The proposed amendments just went too far, broadened the scope impermissibly under Section 59, and therefore the original rejection was correct.
Okay. And AbbVie's counter-arguments. What were their main justifications for wanting the amendment?
AbbVie basically argued they had the right to amend claims anytime during the process, citing Sections 56 and 59. They felt not amending internationally shouldn't block them in India.
Okay.
They also claimed that since the ADC's chemical structure was described in the original patent document, the product claims were kind of implicitly disclosed from the start, so Section 59(1) should allow them.
Sort of a "it was described, therefore we can claim it" argument.
Pretty much. And they suggested that if the product claims were allowed, then the earlier objections about the method claims under Sections 21J and 3I would just become moot points. And as we discussed, they really leaned on that Allergan precedent.
Right. So we have the law, the facts, the arguments.
Right.
And the final decision, as we know, was the court siding with the controller and rejecting AbbVie's application.
Correct. The Delhi High Court was quite clear. AbbVie's amendments weren't permissible under Section 591. They really doubled down on the idea that you can't use the amendment process to fundamentally change your invention or grab broader protection than you initially disclosed, especially if you're just trying to dodge patentability issues like the Section 3I exclusion for methods of treatment.
And the court made a specific point, didn't it, about this particular move, method to product, by dropping the disease limitation.
Yes, that's a huge takeaway. The judgment gives clear guidance that doing that is exactly the kind of scope enlargement Section 591 is designed to prevent.
So it clarifies things quite a bit.
It does. It sets clearer boundaries for the Allergan precedent, too, showing it doesn't give a green light when key limitations like the specific disease are removed in the amendment process, because that inherently broadens the scope.
So practically speaking, what does this mean for, say, pharma or biotech companies filing patents in India?
Well, it's a strong signal about how strictly Section 591 is interpreted. If you're trying to switch from method claims, maybe because they face Section 3I objections, to product claims, you have to be super careful.
How so?
Those product claims need to stay very closely tied to the original scope, especially regarding the specific uses or diseases mentioned initially. If you try to make them too broad, remove those original limitations, you're likely heading for rejection under Section 591.
Right. And the court also backed the controller's view that the original method claims were unpatentable anyway?
Yes, they agreed with the controller on the Sections 3I and 21J issues as well.
Yeah.
And it's worth noting this was a single-judge ruling, Justice Amit Bansal, and there wasn't any dissent mentioned, suggesting a pretty firm stance.
Okay, so wrapping it all up, amending patent claims in India isn't just a formality. It's governed by strict rules, especially Section 591. And trying to make a fundamental change, like shifting from a specific method of treatment to a broad product claim by ditching key limitations like the disease, well, that's going to face major legal obstacles.
That really sums it up well. It underscores how important it is to get that initial patent filing right, make it precise, comprehensive, and really define the invention clearly from the get-go.
Absolutely. And maybe that leads to our final thought for you, the listener, to chew on. Given these quite strict rules on amending patents in India, what are the wider effects?
Good question.
Does this push companies towards, extremely careful initial filings? Or could it, maybe unintentionally, make it harder to protect genuine innovations, especially as scientific understanding grows after the initial filing?
Does it help or hinder innovation and access in the long run?
Exactly. Something to really ponder. And that brings us to the end of this deep dive. Thanks so much for joining us.